And there are obviously many reform movements around the country, some of them based on constitutional factors under the Eighth Amendment, due process, equal protection, and the like. And happily here in Connecticut, the legislature has just passed House Bill 7044, which will be forwarded to the governor for signature shortly, which does bring about some serious reforms in Connecticut's system. So with that, I am really pleased to introduce our illustrious panel, and going alphabetically order, Scott Bales at the furthest right of this panel, yours, is the Chief Justice of the Arizona Supreme Court. He's had an illustrious career, having clerked for U.S. Supreme Court Justice Sandra Day O'Connor, served in the Justice Department as U.S. Attorney and a Deputy Assistant Attorney General. He returned to Arizona, where he was the State Solicitor General and also worked in private practice before joining the Supreme Court of that state in 2005 and then ascending to Chief Justice in 2014. Jonathan Lippman, immediately to my left, recently stepped down as Chief Judge of the New York Court of Appeals, the highest court of that state. That capped 20 years of service in leadership positions throughout the judiciary of the New York system. And as he moved to the top of that system, he instituted a number of initiatives that gave national attention, improving access to justice, increasing pro bono service by lawyers, especially new lawyers, addressing systemic causes of wrongful convictions, and also a focus on issues of human trafficking, juvenile justice, and bail reform. Chief Judge Lippman is now at the firm of Latham & Watkins, where he helps lead their pro bono practice. And then finally, Chief Justice Stuart Rabner of the New Jersey Supreme Court has held that position now since 2007, having previously been Attorney General of the state of New Jersey, and then before that serving in the federal system as First Assistant U.S. Attorney for the District of New Jersey and as Chief of the Terrorism Unit for the Office of the U.S. Attorney for New Jersey, where he supervised that office's investigation in New Jersey of the September 11 terrorist attacks. So we have a superb panel, and we in Connecticut and those of us from other locations as well are going to be very fortunate to hear their perspective on this tremendously important issue. And so with that, I'm going to ask each of them to give a brief overview of the state of play in their jurisdiction. And Justice Bales, could we start with you, please?
Sure, but first let me say thank you for the introduction and the opportunity to be here. I really admire the work of Governor Malloy, and putting this kind of conference together I think is very, very important, and it's a privilege to be on this panel. Every time I get a chance to listen to Justice Lippman and Justice Rabner, I learn a lot. While I came first alphabetically, I'm actually the most junior among us. I only became Chief Justice in 2014. So it's truly a privilege to be here. I need to start, I guess, by giving you a little bit of a sense of Arizona, because if, like me, your image of the state is grounded in television or vacations, you may think of it as the Grand Canyon or the Painted Desert or saguaros and Wile E. Coyote and the Roadrunner. And there's some accuracy to that. Arizona, we have a population about twice as large as that of Connecticut. Our population is a little more than 7 million, so we're about the same size as Massachusetts. But our land area is about 20 times that of Connecticut. And while that may suggest relatively dispersed populations, and parts of our state are like that, at the same time, Maricopa County is the 4th largest county in the United States after LA, Chicago, and Harris County, where Houston is in Texas. So with some 4.2 million people, that county is densely populated, and it's the fastest growing county in our nation. Incredibly diverse state. About a third of our residents live in homes where a language other than English is regularly spoken. We have a large Latino population, a large Native American population, a large number of people who like me, have come to the state from someplace else. And that kind of population growth and diversity and transience creates all kinds of challenges for our justice system, not just our criminal justice system. Our court structure in Arizona, on the one hand, is in some ways centralized, and in other respects, not centralized. We have general jurisdiction courts in every county, but we also have limited jurisdiction courts which handle many of our relatively minor offenses. And of the 100 and some judges in those kinds of courts, some of them aren't lawyers because they're not required to be under our Constitution. We still have justices of the peace. Some would say 19th century anachronism, but that's the system we have. So we have a lack of centralization in terms of the funding of our courts, but at the same time, our Supreme Court, under our Constitution, has administrative oversight over all the courts in the state, and that's exercised through the Chief Justice. In Arizona today, there are about 10,000 people in jail. That's our average jail population. 60 to 75% of those are people who are simply awaiting the disposition of their charges. More than half of those individuals have a history, if not a current problem, of some combination of substance abuse or mental illness. And we know, sadly, that a significant portion of those individuals are there because they're not able to pay bail for their release. I'll give you an example that is, to me, a striking illustration of the nature of this problem. A couple of years ago in Flagstaff, one of those towns along Route 66, a person named Floyd Leissman was arrested for the crime of sleeping in the parking lot of a Barnes & Noble bookstore. I guess that's trespassing technically. He languished in the Coconino County Jail for 4 days because he couldn't pay a $250 bond. Around the same time, an individual named Jonathan Dwyer was arrested for headbutting his girlfriend because she refused to have sex with him. Well, he was a professional athlete and was out within a day because he could pay the $25,000 bond without blinking an eye. That points out to me the problems of a cash bail-based system. It's using a net that's too fine and at the same time too loose. We hold people who shouldn't be held merely because they don't have money. We let people go who should be held because they do. In Arizona, a few years ago, I realized we didn't really have a uniform system of pretrial services. Our various courts varied in terms of whether they even used risk assessments or whether they had the means of providing supervision for people who were released pending the disposition of their charges. We, largely based on our rulemaking authority, began an effort to implement statewide a risk assessment tool. It's the Arnold tool, which many of you will be familiar with. It's a sort of objective, very easy to administer 9-question based test that helps measure both the risk of non-appearance, the risk of committing a crime while on release, and a third indicator for potential violence. We first did that as a pilot project. It was very well received, and we used that reception as a basis for, in 2015, again through administrative order, directing the statewide implementation of that assessment tool. That was a factor in my setting up about a year ago a task force that was looking not just at pretrial practices, but also the way we use fines and fees. But one of the principles that guided the task force was that our determination whether someone is released pending disposition of the charges should not be based on their resources, but instead should be based on the risks they pose of either non-appearance or committing a crime while on release. That task force completed its recommendations last fall and had a significant part of its report under the heading, Eliminate Cash for Freedom. And to do that, we are in the process now of, through court rules, requiring our judges at the stage of the released detention decision to consciously impose the least onerous restrictions that can be identified consistent with assuring appearance and protecting safety. And we've given them through the forms that are used and through the applicable rules, a menu of options. That we can do in Arizona without needing a constitutional amendment or a statutory change. The challenge and what we're on the eve of beginning to work on next is getting the judges actually to buy into this, because they come from a background where some of them have in their jurisdictions schedules, and they know that a certain offense, like sleeping in the parking lot, I guess, on the grounds of Noble, cost you $250 to get out. We have to overcome that. We're doing it through our various education programs for judges. Another thing that we have uniformity in on the mandatory education requirements. And just next week, we will be holding our annual Judicial conference, and we're drawing on people like Judge Truman Morrison and Eric Washington from the District of Columbia and others who've been leaders in their jurisdictions to try to convince our judges of what I think is indisputably true. If you care about fairness, if you care about public safety, if you care about using public resources responsibly, you're going to recognize that using bonds is a very bad approach to deciding who stays or who goes pending the disposition of charges. So in terms of the state of play in Arizona, we've been able to make, I think, steps in the right direction, often borrowing from other jurisdictions like the District of Columbia. And the big hurdle on the horizon for us is getting the buy-in from the courts, which is going to require, in many ways, not just changes in rules, but changes in the culture and the practices by the judges and also by the prosecuting agencies and the public defenders.
Judge Lippman.
Okay, it's a delight to be with all of you and to be with my colleagues, and we have discussed this issue among the chief judges, chief justices for many years, and I'm so pleased that that there's being progress made, including here in Connecticut. So let me start by saying that as chief judge in New York, I felt certainly that it was one of my primary roles to be able to put criminal justice reforms on the table that sometimes the political branches were not able to look at outside the context of the political pluses and minuses. And as the non-political branch of government, maybe we had a little more freedom to be able to raise these kinds of issues. And I was, as a chief judge, a strong advocate of bail reform and pretrial justice reform. The bail statute in New York is one of the minority of states who do not allow judges to consider public safety in making bail decisions. It's a little bit of a fiction because judges are human beings, and of course they do that, but basically the statute ties that decision to whether you're going to return, your ties to the community, and that kind of thing, but you're literally not permitted to consider public safety. And then this bail statute has 9 different methods of things you can do: bail, unsecured, partially secured, bonds, and all of the rest. But in practice, judges just use cash or a bond, and do not use all of the tools in the statute, and again for the same reason that I mentioned to you. Judges are human beings. They don't want to be on the front page of the tabloids. Judge releases X, who goes on and does something terrible, and then the judge is blamed for it. My own view is that sort of similar to what Chief Justice Bales was saying, that your liberty should not be determined in New York, it's not determined by the judge, it's not determined by the prosecutor, it's not determined by the defense attorney, it's determined by you-know-who, the bail bondsman. a profit-making institution that seems to me just to be so foreign from the idea of justice and the sacred idea that people are presumed innocent and should be at liberty unless there's an awful good reason why they're not. In 2012, I raised this issue front and center in one of the state of the judiciary that year. And then in 2013, I submitted legislation in Albany that basically did two things. One said that judges could and must consider public safety and dangerousness in their decisions on bail. And second, the bill essentially flipped the presumption. Where right now in New York, the presumption is you're in unless there's a reason for you to be out. The bill that we submitted basically changed that you're out unless there's an awful good reason that you're going to be in. And in its simplest form, my view is if you're going to hurt somebody, we put you where you can't do that. And if you're nonviolent and you're not going to harm society, then you should be home with your family, in your communities, while you await the judicial process. So that, when I started this reform movement in New York, got a lot of attention. New York Times had a front page story saying, Chief Judge says, bail system unsafe, unfair. And we got a lot of talk about it, but talk is different than getting legislative action, which is required in New York. So that bill and the successive bills that I put in really were stymied. We were talking a little bit before we started with the tough on crime, soft on crime syndrome. No one wants to be smart on crime, and that is the case with many of our well-intentioned political folks, but who factor in, that they have to run for re-election. What we did when we didn't get the bill is, administratively, we put into place a system where after, and it's not that dissimilar to something going on within the bill in Connecticut, that after the judge's bail decision, which is made when the defendant is arraigned, we required that I required, and the judges were very pleased, you could be sure, that there be a second judge who within a very short period of time after that initial decision looked in a more deliberative way at the bail decision, why that person is in, because in New York, we have such large calendars that these decisions are made very quickly. In a 5-minute appearance, the judge decides, to take away your liberty unless the bail bondsman decides to bail you out. And so the judges thought that was second-guessing what they were doing. I felt it was more in the nature, again, of this serious thing of incarcerating someone, especially when they haven't been convicted of anything, to take a second look at it in a more careful, deliberative way. Really, I was advocating in those days the DC model, which I still think is great, where they've done away with cash bail altogether. And in New York, there's new momentum for bail reform. One, we've had a number of criminal justice reforms in general in New York, juvenile justice reform, wrongful convictions, indigent criminal defense have taken place in this last session, in this session. And the governor is committed to bail reform. Exactly what his bill or policy will look like, we're not sure, but he does have it on his agenda. And the other things, two things that have contributed to the momentum for bail reform is one, the Khalif Browder situation. Scott mentioned the situation in Arizona, in particular instances in New York. You've probably read about it. It's in New Yorker magazine. This poor young man is accused of stealing a backpack. He refuses to take a plea. He's 16 years old, and we have corrected that now. The judicial process takes too long. He's in for 3 years, and the reason he's in is because his mother can't make $3,000 bail. Kid is abused at Rikers and comes out and kills himself, and this whole situation written up in a very moving article in the New Yorker magazine. And so that's created a lot of tension. And then there's a commission that I've headed, the Rikers Commission, which is looking at the future of the Rikers Island jail facilities, which is a symbol of everything that's wrong with the criminal justice system in New York and around the country. And that commission recommended that we close down Rikers, and that the mass incarceration model doesn't work, but also recommended that in addition to a number of criminal justice reforms, that we do away with cash bail in New York. We looked at Rikers where 80% of the people haven't been convicted of anything. 88% of them are people of color. 50% of them are there for 3 or 4 days or less. And we didn't see, this commission, any reason why the bail system as it exists really is the worst thing. It detracts from public safety rather than helps it. This is a place like Rikers, whether you're in for 3 days, 3 weeks, 3 months, or 3 years, you come out worse than when you went in. It's an accelerator of human misery, especially for people who are there because they're poor. So it doesn't make any sense to me. We now have the mayor and the governor on board to the criminal justice reforms that we proposed and closing Rikers. Whether we can translate that into legislative reform remains to be seen. We have on the left side of the equation the words preventive detention are the worst thing you could possibly do if someone is in this or a threat to public safety. And on the other side of the equation, putting people, even if they won't hurt anybody, even if it's at public expense, putting more people to be free out on the streets, again, is a threat to public safety, which to me is absurd given the people that we often have in, with low levels of bail for relatively low level crime. So that's where we are. We're looking at our friends in the other states, what you're doing here in Connecticut, what Judge Rabner has done and the legislature has done in New Jersey, and the efforts that Judge Bales has been making for a considerable period of time now in Arizona. And again, we're hopeful that the time is right for reform in the pretrial justice system, particularly in bail.
Thank you. And Justice Rabner, you've just gone through a major reform in New Jersey, is that right?
It is. Thank you, Dean. And first, let me also thank everyone for inviting me and allowing us to participate in this conference today. It's an honor to be with my colleagues up here, and I'm very impressed by the efforts underway in Connecticut. I looked at the Sentencing Commission's report from earlier this year. You have a lot of fine work and more that lies ahead from what it appears. Let me spend a few minutes giving you a sense of the problem that we saw in New Jersey, the steps that we took, and where things stand at the moment. As you heard from the other chiefs, the problems that we saw in New Jersey are not that different from what exists elsewhere. Too many poor defendants sitting in jail, even if they pose a minimal risk of flight, a minimal risk of danger, because they can't afford to post bail with real consequences for their jobs, their family life, and the disposition of their case. And on the other end of the spectrum, individuals who've committed serious crimes who do pose a serious risk of danger and flight, because the New Jersey Constitution for so many years, like Connecticut's, had guaranteed the right to bail. If they had access to money, they were able to get out, notwithstanding those risks. So a number of years ago, our governor came forward with a proposal for pretrial detention similar to the federal model. The legislature, controlled by the opposite party, did not endorse that, and the matter remained unresolved for some time. The catalyst for change, the eye-opening event for us, was a study that was done by Dr. Marie Van Nostrand, who's affiliated with the Arnold Foundation that you heard about and many of you know about as well. She took a look at a single day in October of 2012 at our county jail population throughout the state. And the results were eye-opening and alarming. the high percentage of individuals who were in custody because they couldn't make bail, 1 in 8, 12%, were held because they couldn't post even modest amounts of bail of $2,500 or less. And they were held sometimes for weeks or months on end at a significant cost to taxpayers as well. So that report gave us the opportunity to broaden the conversation and bring both sides together, as you just heard the chief allude to. The judiciary created a committee, an advisory committee on criminal justice, invited members of all 3 branches, 33 individuals, the governor's chief counsel, senior staffers to the legislators in both houses on both sides of the aisle, judges, prosecutors, defense attorneys, representative of the ACLU, and others to sit and talk about pretrial release and the Speedy Trial Act, the need that we have. I chaired the committee, and I reached out to the Attorney General and the Public Defender and asked if they would personally attend the sessions, which they agreed to do. And I believe that their reasonableness throughout the process was pivotal to our success. We met for 6 months, studied these issues, and at the end issued a report with 27 recommendations, as to which there was near unanimity, with one condition, that the recommendations be considered by the legislature as a package, not splintering them, which we feared would splinter the progress we were hoping to achieve. And the 2 most important recommendations for our purposes today were, number 1, move away from heavy reliance on monetary bail and instead use an objective risk assessment tool to measure the risk of danger and the risk of flight, such that low-risk defendants could be released on conditions that would be supervised by pretrial services officers. And at the other end of the spectrum, the recommendation was for a change in the Constitution to remove the guarantee of bail and allow for pretrial detention in cases where there is that serious, substantial risk of danger of flight, a very real public safety concern, in line with what the governor had proposed. And then separate from that, there was a proposal for a Speedy Trial Act that has become law as well. Now, not lost on anyone was the fact that these recommendations, as I said, that were nearly unanimous, came from a group that doesn't always see eye to eye on issues. The response from the legislature and from the governor was quite supportive, quite strong. And in the months that followed the report, they embraced a number of those recommendations. They were grafted into the statute. The judiciary was invited to help in the discussions about the language in the statute, passed and signed into law in September of 2014. I have deliberately truncated that story. It wasn't quite as smooth as it sounded. Let me, instead of getting into the politics, tell you that we got from point A to point B. It wasn't a perfectly straight line, but we did manage to get to point B. What followed was a public vote for a constitutional amendment in November of that year, with strong support to change the Constitution and allow for pretrial detention in those limited circumstances. The bill was slated to go into effect January of 2017. At the time, it seemed like an eternity. And the judiciary took those intervening 2 years to spearhead the efforts for change and ready ourselves to implement this system, working closely with the Attorney General and the Public Defender along the way. And we learned from and drew on experiences from DC, and Judge Morrison, come back this afternoon. You'll benefit from hearing from him, talk to you about the tremendous efforts that they've engaged in leading the nation from Arizona, from Kentucky, and elsewhere. And our preparation focused on 5 principal areas. Number 1, working with the Arnold Foundation to develop a risk assessment tool. And you will be delighted to know, those of you who are involved in policy in Connecticut, it was free. They devoted thousands of hours and expertise without charging the state anything. And they developed a tool that was tested with tens of thousands of actual New Jersey cases. They have a database of more than 1.5 million cases, coming up with a model similar to what Chief Bales described earlier, 9 common sense factors about the offense, the defendant, the person's background, that factor into the release recommendation. Second, we developed and harnessed new uses of technology in order to ensure that we get as much information as possible to the judge within 24 to 48 hours of an individual's arrest. And that involved everything that you could imagine. You know, we're all familiar from TV that fingerprints are done the old-fashioned way with ink pads. They are now done almost throughout all 500 plus police departments throughout the state electronically on a live scan system. Why? So that we can readily access databases across state government, federal databases from other states where individuals, you know, where the Daniel Smith that has been arrested in New Jersey may have committed other crimes within a matter of hours, to compile that information and to present it to the judge. We prepared for a new pretrial services agency. None had existed in the state, and they're tasked with two important things: developing a public safety assessment, the individualized risk assessment for each of the tens of thousands of defendants. We anticipate more than 50,000 reports this year that pretrial services officers prepare, and also monitoring those defendants that are released on conditions. And the monitoring can range from nothing more than a text message telling that low-risk defendant, you've got a court appearance next Wednesday, make sure that you show up, to electronic monitoring and home confinement for those who present greater level of risk. And that involved all sorts of logistical things like hiring, training, finding space, developing a manual and a protocol for what these officers should be doing. Today we now have about 180 pretrial services officers and staff in courthouses throughout the state. We formed a group of judges, attorneys, and staff to comb through the criminal rules and make changes that are necessary in order to implement the new law. If you're having a hard time sleeping, this is the document you want to look at night. It's on our website. It was a very important task, and the court endorsed the recommendations that are now part of our court rules. And finally, and perhaps as important, if not more important than anything else, we engaged in a series of outreach efforts throughout the state, more than 100 programs all throughout that 2-year period. First, we needed to speak to the judges. Judges who for decades had been accustomed to setting bail, because that's how it was done. And what we were talking about was a change of mindset, a sea change in the way the court system had functioned, and we needed to persuade the judges, the prosecutors, the public defenders to get on board with this new system by talking about its advantages. And second, we had broader outreach efforts to the criminal justice stakeholders throughout the state, wardens, sheriffs, community groups, public officials, to explain what we were doing and get their buy-in as well. Next step for us was to have pilot projects for 2016 where we could kick the tires of this new system in advance of it actually going into effect. And we chose 3 counties throughout the state where we had skeletal crews of pretrial services officers doing a mock assessment, and then Monday morning quarterback sessions, as we refer to them, where the judges, the pretrial services officers, prosecutors, defense attorneys, and others would sit together and work through the model and see what worked and what didn't work. And that happened in all 21 counties shortly before we flipped the switch this past January 1st. When we did so, it was the first time in our state that we have had honest conversations about pretrial release. Judges know that if an individual presents a substantial risk of danger to the community, a substantial risk of flight, they're not going to be imposing an artificially high bail that nobody expects the defendant can reach. They can now detain that individual. And in most cases, where they correctly believe that the individuals can be released, either on a promise, their own recognizance, or on conditions, they can impose that as the order of the court. It's important to note that the risk assessment tool is not making that decision. It comes forward with a recommendation to the judge. Judges have the final say, and that's how the system is unfolded. Here's what they have said. We've tracked statistics since January 1, and in the first 4 months, from January until April of this year, we've seen a remarkable change in practice in our state. 13,600 defendants have had their cases processed during that period of time, and of those, a little more than 1,800 have been detained. It's about 13.5%. A little more than 10,000 have been released on conditions, roughly 74%. Approximately 1,300 have been released on their own recognizance, about 10%. And the number of times in which bail has been ordered in our state from January through April is 12. 12 defendants out of 13,600 cases. The upshot for that is the most dangerous defendants in New Jersey have been ordered, detained, and held behind bars until their matters could be resolved. And no one arrested since January 1st, except perhaps for a dozen defendants, is sitting behind bars because they're too poor to be able to afford bail. That didn't happen by accident. It was a result of that collaborative effort, those outreach efforts, working with all the players in the criminal justice system to educate, to retrain, to recondition how we approach what had become a reflex and set a new default of release on conditions, with the exception for those cases where detention was required. Now, it's a bit early to say definitively, but we've noticed two other trends as well. The first is a significant reduction in the number of warrants. Like Connecticut, we have a summons warrant system in New Jersey, and we've seen a dramatic reduction, which we believe is due in part, at least, to the fact that prosecutors have gotten more heavily involved at the very earliest stage of the decision-making process. They're screening cases and making decisions at the outset, as opposed to a month or two down the road, about which cases should proceed with a warrant that leads to the pretrial assessment and the system that we've just talked through, and those which should be handled instead by summons. And we've also seen a significant reduction in the jail population during the first 5.5 months of this process. That wasn't the purpose of pretrial reform, but it's a notable consequence. We have a lot of work ahead of us. First, we're going to feel the pressure of speedy trial 6, 9, 12 months in, based on the timelines imposed in the statute, and that'll impose a great deal of additional work on our court system and on our judges in particular. And second, we have all throughout been looking at the decision-making framework that judges rely upon and listening to critics of the system, to counsel, to public officials, to law enforcement, about areas where they have recommended changes. And just 2 weeks ago, the court imposed changes in 2 different areas. The first, for repeat offenders. The system, in our judgment, did not adequately track individuals who committed relatively less serious offenses. A third-degree residential burglary, for example, would typically result in the individual's release, but if that person goes out a second and a third time and commits the same offense within a matter of weeks or months, that third arrest will now trigger a recommendation of no release, even for a third-degree crime, which is not what had been the original design. And second, we've looked at firearms offenses. And recommendations for the judge will now include an increased level of monitoring, and in some cases, a recommendation of no release based on the severity of the firearms offense. We're going to continue to look at the decision-making framework, and we made these changes only after consulting with Dr. Van Nostrand and the Arnold Foundation and the experts that we have been working so closely with. Now, we have also come under criticism from a number of quarters. No surprise. People don't like change, and this is a monumental change. And it's been quite understandable to have vigorous criticism by the bail bondsman industry. Their industry in New Jersey is under siege, just as has happened in DC decades before. And some of the criticism has been in the nature of Monday morning quarterbacking itself. Why did you release this defendant? Why not detain this individual? Look at what happened, look at what might happen if you allow this serious offender to be out on the streets. Even though last year, and for so many decades beforehand, there was no pretrial detention. You couldn't detain an individual in our state because of the serious nature of the offense or the danger that that person presented, and people who got out on bail did in fact commit serious crimes. Now, it's too early for us to assess the system overall. We need data in order to be able to compare what's happened this year as compared to years prior with regard to the percentage of individuals who have failed to show up for court and the percentage of committed new criminal activity on release. But from the preliminary data that I've shared with you and that we have been carefully watching, I think it's safe to say that the system-wide changes in place have helped us move in a direction of a better, and a fairer system of justice in our state. We've been lucky to have very strong support, continued strong support of the governor and the state legislature, and by and large, the major media outlets in our state that have covered this story. That's where things stand at the moment, and a sense of how we got to this point.
Well, thank you, Justice Rabner. Let me ask all of you who have been involved in these reform efforts, what have been the key steps and points that have won over skeptics about this kind of progress?
Well, let me just start by saying that, I think I mentioned in my remarks that the really bad horror stories get people to the point where something has to be done. So I think we've had a lot of momentum growing around the story that I told you about this young man that so highlighted the flaws in the criminal justice system, and in particular the bail system. It's almost a rallying cry. So I think out of the worst of times, sometimes good things can happen.
Well, and I think another important angle on this, at least in Arizona, has been appealing to those groups, the prosecutors, the boards of supervisors, who are concerned about issues related to public safety and to fiscal responsibility. One point that I think was behind what we were saying when we were focusing on bail reform is there's really a broader issue about how do we reduce our jail populations, because it's tremendously expensive to hold people in jail. In Arizona, it's about $85 a day. I suspect it costs even more in the east. So that's in my state, hundreds of millions of dollars. We know from research that the Arnold Foundation did nationally and research we've done in Maricopa County that for relatively low-level offenders in particular, every day you hold them in jail makes it more likely they're going to commit a crime when they're ultimately released. So if you think about it, this is perverse. We're spending public money to create crime insofar as we're holding people unnecessarily pending the disposition of their charges. We also know that for those individuals, releasing them on an unsecured bond, a promise that if they don't show up, they're going to have a financial obligation, that's just as effective as holding them on a secured bond or a cash bond. So in arguments that we've made in Arizona for reform, while in my mind the fairness and perhaps the background constitutional issues are very compelling, for certain audiences it's a very powerful argument if you say you can improve public safety by making these kinds of reforms, and you can save money. And I think it's important in these reform efforts to recognize that there are multiple reasons to do this, and in some cases you have to make the argument that's going to best appeal to a particular audience.
I agree with that, that's for sure.
I agree as well, and I think the broader public can appreciate the unfairness in the system when you talk about it in the way that we are, and get the sense that we're keeping the wrong people in prison based on a system that relies on a flawed money bail system. We've done a couple of things. For one, we stay in very close contact, and this isn't the group of skeptics, but it's our partners, if you will. We have monthly meetings with the Attorney General and the Public Defender, going back 2 years now, and the courts, to talk about anything and everything that needs to be touched upon. I write regularly. I've become a great pen pal of the governor and the leaders of the legislature, and I'll keep doing it until they tell me they've had enough, just so that they know what's going on and are informed about the changes since January. And then there are the real skeptics. I'm not talking about the bail bond industry. We're not going to convince them. Law enforcement that is troubled by individual decisions. Those anecdotal cases or beyond that, they see some of the individuals in their towns that are being released. We meet with them. Just last week, I had a meeting with 5 chiefs of police and the administrative head of the court system, and the only condition was that our discussion stayed in the room so that it could be candid. And we'll keep doing that because we learn from each other. And then a great challenge for us is the media, because they don't have a real sense of where they should come out necessarily. They're hearing disparate voices. They're hearing some of these emotional stories about somebody victimized by somebody who has been released, and don't appreciate that. What we've said to all of them is, please, before you write your article, spend 3 hours, spend a day in the courts, and watch an entire calendar being called so that you can see how this system works. You can see what the judge is doing, what factors are being weighed as they decide whether to release or detain an individual, and you'll get a big picture perspective of how pretrial release is now being done in New Jersey, as opposed to writing an article that focuses on an upset victim, an anecdotal story. And the reporters that have accepted that invitation, and then they get, and we make sure that they can speak to the judge afterward and ask questions that were on their minds. Some of them have actually said to us, I'm not going to write the story, because where I started isn't reflective of the current system. Those that don't want to go to court and seize upon the anecdote and want to write about that, we're not going to be able to persuade them.
But you know, based on the things that we're all saying, I think the hardest part, though, it's easier to show that it's unfair than to show that what we do now does not promote public safety. You know, and the unfairness people get, the public safety things people are very emotional about and don't necessarily think logically about it. You know, and I think that's what we all battle with on this.
Judge Lippman, many of these efforts come at the same time as a series of constitutional challenges in certain jurisdictions around the country. Perhaps since you're not going to be making any of these decisions from the bench in the near future, you could give us an overview of those challenges?
I'm going to be bringing those challenges.
All right.
No, well, there are obvious constitutional issues that are involved. You know, the right to counsel, you know, the Sixth Amendment, excessive bail, the 8th, due process, equal protection, the 5th and the 14th. You know, the most significant one that's gotten the most attention is this Harris County, Texas, that basically makes the point that we all know by now, which the Beard case in the Supreme Court has told us, is that you can't keep someone, it's unconstitutional to keep someone in because they can't afford to pay it, you know, to pay the bail, and that's such a basic principle, and I think that was the foundation of what happened in Harris County, Texas. Also that, I think they have these bail schedules, which says a certain kind of crime costs you X amount of dollars, you know, on the bail, and that goes against the requirement that we know that when you're talking about what's excessive, what's constitutional, it has to be particularized to the individual person that you're talking about. Even risk, which the Salerno case in the Supreme Court tells us that you can. It is constitutional to say that you're going to be held having some relationship to the risk that you pose, but it's the having some relationship that's the issue. Is it calibrated to the risk that you actually impose, or is the whole thing just violate substantive due process, that it's just some preventive detention, for example, is just some punishment that has nothing to do with the particular risk that you pose. So the basic idea that money can't be, it can't be the amount of money in your pocket that determines your liberty is the basic constitutional principle that I think has been upheld. And then there's all kinds of variations on the theme of the constitutional area. There's issues as to, are you entitled to a lawyer when bail is being imposed? Is that, well, the bail decision is being made, is that a critical stage of the criminal proceeding? You know, I did a decision in New York that was about a case called Harold Herring that was about systemic challenge to indigent criminal defense system. in our state. And I said loudly and clearly that point, the first appearance in a criminal case, is a critical stage of the proceeding. But a lot of these things are up in the air, not crystal clear, but I can tell you that around the country, people are focusing on it, and some of the stimulus towards reform comes from what we all recognize, and again, the sitting judges may have to deal with some of these challenges, but at the very least, everyone realizes there are serious criminal, constitutional issues with taking away someone's liberty, particularly before they've been convicted of anything. And there are all different pieces of this that go to, again, due process, equal protection, what is excessive bail, and when do you have a right to counsel in this kind of area.
Well, wonderful. At this point, we'd like to open it up to you folks to ask questions. This is a very informed audience, and I know you've got a number of good ones, but we're glad you're here. Anyone? Judge Devlin.
Well, in New Jersey, you know, I assume you had a process where most arraignments were 5-minute proceedings, bail is set, and the new date is given. So if a case is eligible for pretrial detention, how much burden has it been on the trial courts to sort of implement that?
So you get 3 days. The prosecution can come forward at the first hearing and say, we'd like to move to pretrial detention, and the hearing is set 3 days off, and it can be pushed back an additional 3 or 5 days, depending on if either side asks for it. We have seen on average that the hearings last less than a half hour, probably in the neighborhood of 20 to 30 minutes, not that different from the federal system. There's a case right now in front of the court as to whether the prosecution can proceed by proffer or has to call live witnesses. And that's all I'll say on that. And there has been a ruling by the court requiring the state to present discovery in advance of the hearing, which goes beyond the federal system. That's been in place and that has been working. It's discovery keyed to the probable cause determination. So the defense gets the incident report, the police report. The short answer is, it has not overwhelmed the system.
Let me also say that you raised that point, that I think one of the reasons the DC system has worked so well is they have very healthy defense services. When you have these preventive detention cases, you've got to have a robust ability for the defense to give their side of it, and that's one of the objections in New York to the idea of preventive detention, is this idea that, gee, is the defense going to have the resources that they need to make sure that these hearings are meaningful?
And for those of you who want to hear more about the DC system, Judge Morrison, who's here with us right now, will be on the panel this afternoon, so that'll be good. Others? Yes?
I wonder if we can talk about conditions that would place in defendants, and do you have concern of over-conditioning, especially if we move away from mind-based system?
Very much so. The message that we have been giving the judges and what folks have been guiding us is don't over-condition, because it can lead to failure and a revocation. Then you're talking about possibly incarcerating someone on a relatively minor offense. So as laudable as the notion of treating a drug addiction problem, for example, as part of the pretrial release component, we have encouraged our judges to minimize the conditions in order that individuals show up and don't commit crime. We also don't have the funding in our system. You know, I've admired the DC system. I think they have about a $50 million system for the annual cost for the District of Columbia. We've got nearly 9 million residents and $21 million. There's no money for some of those laudable extra purposes. So our message has been clear from the outset: do not impose so many conditions that the defendant will fail.
Let me just say on the drug thing that we've had that issue come up in New York a lot, where, you know, we have all these drug courts and it's this tough love regimen where you say you must complete the program, and, you know, the judge may take some lapses, but it creates I happen to be in favor of that. I think it's worked very well, but there are lots of fault lines in it where you condition everything, and the defense, we had to do all kinds of persuasion to get the defense community to really go along with this, because there are sometimes, I think, in Chief Justice Rabner's words, you set yourself up for failure. So it's not so simple.
And that's an important distinction. We have the same drug court program and the same type regimens, but that's after the disposition of the case, and that's part of probation in other cases where you're not part of the drug court program. On the pretrial end, we have not gone down that road.
Well, and one thing we've been doing as part of our efforts in Arizona is we've been revising our standardized forms for our release orders, so it underscores to the judges that there's sort of a gradation of options, and then consistent with the directive that you impose the least onerous conditions that the judge concludes would be sufficient to secure appearance and prevent crime on release. It tries to get over this sort of mindset where you just automatically impose this list, which may have various conditions that are unnecessary and just trip people up for no good reason. And we've also learned in Arizona, I suspect this is true in other jurisdictions, we've learned from our post-conviction probation work that paradoxically, fewer conditions can help result in less recidivism. Because again, you create technical violations that don't really relate to the serious long-term rehabilitation of the individuals. But our success there is something that we're going to try to leverage in convincing the judges that you don't just need to impose a laundry list unthinkingly for every defendant who's going to be released pending the disposition of their case.
In New Jersey, what type of considerations have been given to specific types of crime, such as like domestic violence or drunken driving, where there may be lower statutory penalties, but threats to particular individuals or the public may be contemplated based on the type of charge?
So it factors into the public safety assessment that the risk assessment tool is doing. They look at the particular offenses, and it factors into the decision-making framework that the judge goes through. And those are the very arguments that you would expect to hear and do hear. The statute itself has two presumptions in favor of detention, unlike the federal statute, which has a greater number that our legislature considered and rejected. Capital offenses and offenses that expose the defendant to life imprisonment carry a presumption of detention. Beyond that, it's the recommendation and the argument of counsel focused on the offense in particular.
I noticed though in the Connecticut report there's a great focus on domestic violence.
Yeah.
And that's not surprising. And in a lot of the things that we do in criminal justice, and I'm sure it's not that different in the other states, there are usually carve-outs, in particular areas. But judges are supposed to judge. And you give them the tablet, and then they make decisions, and then the other side of it is they have to take responsibility, and it goes with the terrain that people sometimes don't like what you did or criticize you for.
My concern, especially listening to the dangerousness hearings kind of have to happen within 3 days, particularly in domestic violence type of situations, just being able to get that type of material in 3 days in a domestic violence type of situation where people frequently don't even give a statement initially because they're terrified that the police are there and that they don't want to participate. It takes longer than that. So it's just, I'm wondering how that's contemplated into the system when frequently these decisions are being made kind of in real time.
So it's actually worked out in a positive way as well, and some of this is anecdotal from what I hear from judges in the trenches. That type of case, you would expect that there'd be a request for an extension of time, so it would be either 6 or 8 days after the arrest before the hearing would take place. And the prosecution would interview the victim so that you wouldn't be going off of the cold report from the first day. And what we have found is it either strengthens the case considerably, or sometimes the victim comes in and says, no, this isn't exactly you know, what the report says, this is how it happened. And I'm not urging detention, and here's why. So we're able to flesh out the issue either way in that period of time. Previously, that could take weeks or a month before that interview took place. So it's been quite helpful.
Attorney McGraw.
So I work with innocence claims and post-conviction habeas petitions for a new trial. I'm curious, I mean, obviously it's way too soon to tell, but do you have a sense of how the ability of the defendant to participate in his defense might affect wrongful convictions? That's the first thing that comes to my mind, because of course I'm constantly reviewing ineffective claims, failure to investigate claims, and we do see an enormous amount of that kind of Sixth Amendment violations impacting the ultimate outcome of the case.
Well, I can't speak in terms of Arizona's experience responding to your question, but the Harris County decision that Justice Lippman referred to, it's O'Donnell versus Harris County, Judge Rosenthal in that case talks about some evidence that was presented in that case and some studies that suggest that at least there, the bail system was resulting in people pleading guilty in order to get out because they couldn't afford bail, and that had, I mean, the implication was that some individuals who otherwise might have been found innocent were pleading guilty.
Most assuredly.
And I believe that if I remember correctly, she referred to some national studies that were really
And additionally, in Connecticut, we have a very strong victims' rights approach in the criminal justice area. People, right now, I think before the Connecticut Supreme Court, there's a claim that there are certain constitutional rights that the victims have with respect to plea bargaining. So has that been a significant part of your discussions about pretrial conditions, pretrial release?
I just say that in New York, we have a sensitivity to that issue, but I don't know, Stuart, was this a major factor when you were trying to put this together?
It has not been. We have a constitutional victims' rights amendment and statute. I can't speak to whether the prosecutor speaks to the victim in these cases before making a decision about whether they're going to seek detention or not. I just don't have that answer, but it has not come up as a major point of
But it's a given that I think in all our states that this is an important consideration.
I expect it's going on.
And the way it came up in our discussions, and it's still somewhat in play, is whether for people who are released, there will be either a mandatory or a presumptive condition of no contact in certain kinds of cases. And I think it also goes to a point that Stuart made earlier about the use of the assessments. You know, they don't make the decision for the judge, and they certainly don't dictate if a person is going to be released what the conditions will be. So it makes, in some ways, it's asking more of the judges early on than a system where you can just obviously look at sort of a schedule and say, okay, given this offense, here's the going rate for bail. But it also, ideally, is going to shift resources, that instead of spending money and otherwise spending resources on holding people unnecessarily in jail, perhaps we can make better decisions by shifting time and effort earlier on in the process and make individualized decisions.
I have a question for the two of you in relation to, I just had this yesterday doing a thing at Fordham Law School on a similar issue, and we got into this whole thing of risk assessments. And, you know, I was advocating that the science is so good today, and I was getting a lot of pushback on the minority issues that do those risk assessments really just make even worse this kind of, at least the perception that the system is harder on minorities and people of color. Are you getting that in both of your reform efforts, that this argument that the risk assessment promotes racial disparity?
Go ahead.
You first.
Well, our task force, which included, and I think this was important, included a cross-section, not just of people from the courts, but from the defense community, from the broader community. We considered that, and one of the recommendations is that we continually reassess through honor or otherwise, whether the assessment itself is as neutral as it can be. Now, you gotta be careful, because there are a lot of different risk assessment tools out there, and some do include socioeconomic factors that might be correlated with minority populations. Does the person have a permanent residence? Do they have a landline phone? Things that, you know, tend to have demographic correlations that might result in disproportionate effects. The Arnold tool doesn't do that. It focuses just on past criminal history, history of appearance. I think the only background factor it uses is age. Now, that said, if you think that systemically the criminal justice system has unfairly dealt with minority populations, I mean, if you imagine that certain offenses were only being charged and prosecuted for certain minority groups, even an Arnold kind of tool isn't going to overcome that. On the other
That's an overarching approach to it.
On the other hand, the argument that I think is very powerful, at least from the experience in my state, is if you look at the old regime where either there was no risk assessment tool at all, or the judges just kind of, they took it or they didn't, that kind of system is rife with opportunities for implicit bias. You know, I've actually heard judges say, well, I want to be able to look at the person and sort of size them up and gauge whether I think they're a risk or not. And I'm thinking, you know. So I think the benefits in terms of fairness, in terms of damping down the ways that different kinds of biases can manifest themselves, I think a good risk assessment.
I agree, but it was very much taken aback a little bit by the extent of the view about risk assessment. Stuart, what have you been getting?
I echo everything that Scott just said. The debate comes up. There are people that are very skeptical of the tool.
Yeah.
That's why the validation process is so important, and the rigorous process that the Arnold Foundation went into in our state looking at these cases was quite impressive. And I think we have to remind people, as Scott was just saying, take a look at the impact under the current system, where there's a disparate impact against people of color who are being held as compared to what we are now seeing. So we need to monitor it. We need to look at impact on gender and race as the new system unfolds, but it's not presenting problems that the old system.
But I think the point that Scott was making is really the case, that there is very much a problem that we have in general in the United States with the perception about two systems of justice, and one for people of color and one for the rich and one for the poor, that we have to combat. But once you get past, you know, that threshold, as you say, I think it seems to me so much more logical to have an effective risk assessment system that's been tested and validated and makes sense to combat the very thing that you know, that we all want to change both the reality and the perception.
Yeah.
Are judges in your jurisdictions elected or appointed? Here in Connecticut, they're appointed. I can imagine situations where they're elected, where their bail decisions may consciously or unconsciously be influenced by public perception and by the next election.
New York is the worst. So we have partisan political elections for judges, which is absurd, and it's not helpful in terms of exactly the thing that you're saying. But let me just say that we also have appointed judges who sit on criminal cases and worry about the appointing authority. And when you have cases like that, you get criticized. Don't think that the appointed system takes you out of that realm. Those appointed judges also worry very much about public reaction to bail decisions and that kind of thing.
Our judges are appointed. They're appointed for a 7-year term, and then if reappointed, and that's the norm, at the end of the 7 years, you can serve, you have tenure until age 70. I'm very pleased that we have appointed and not elected judges.
Ms. Burdine?
So one of the things that's coming up in many of the states that we're working in is sort of this tug of war between the judiciary and the legislature over who has the right to have the final say in the state's bail system. So my home state of Maryland has been sort of every legislative session, bad bills come forward, good bills die, a strangled death. And the court systems there have decided to move in the direction of court rule, which is where I saw some of you at Judge Barbara's event. But that doesn't come without criticism from the legislature that the judiciary is sort of overstepping its bounds. And so I'm just curious as to sort of how you might advise folks like us to think about that and talk about that issue at sort of the legislature versus the judiciary on these bail issues.
Look, we were very fortunate to have the stars align, to bring all the parties together and reach the place that we're at with full support of all 3 branches of government. But let's not lose sight of the money piece, because that's so important to this. We didn't have pretrial services in New Jersey. Had we changed the rules to say presumptively people should be released without any monitoring, then I don't know what would have happened. You know, it's critically important to have some agency out there interacting with defendants during that pretrial period, as you well know. And that only came about through legislative support that gave us the funding in order to do this, that allowed the courts to raise the fees. This is the way that it was done, but be that as it may, without that, we wouldn't have been able to have any form of pretrial services monitoring, and that's critical.
I'd say in New York, you know, we have that issue all the time, obviously, but what's strange is on some of these issues, and I personally did it a number of times, where we don't get something through the legislature, we do it administratively, not as good as if we did it with juvenile justice reform, I did it with bail, and what's interesting is, well, the legislature is not thrilled when you do that. Often we had more problems with our own judges than we did with the legislature. We take something where they feel we're kind of on the edge in terms of what the statutory framework is, and we're kind of, again, doing it in an administrative fashion, and they think that, oh, the bureaucracy is telling us what to do, and we'll decide, you know, how to treat the 16 and 17-year-olds, or what to do. I gave the example of when we have a second judge who we appoint to then go look at the bail decision. You know, it's one way to get bail reform, not the best. And the judges were not happy about it, and I personally took a lot of criticism for doing it. Obviously, I wouldn't do it if I felt that we were outside, you know, totally divorced from what the statute was. But, you know, I think there is, in general, always a tension between the legislature saying, you know, they know what's best in our area of expertise.
Well, and I think, too, I think Jonathan makes an important point about, you know, there are different roads to get to reform. And you operate within the framework within a particular jurisdiction. New Mexico, it took a constitutional amendment. I envy New Jersey, I envy Connecticut in being able to achieve legislative supported reform. Even in Arizona, where I can do a lot through administrative orders and rulemaking, we deliberately went out and sought support, not just from the state legislature, but from the county boards of supervisors, because those are the folks who actually have to pay for the operation of the jails. So if we can get them on board and then get the legislature on board, even if I don't need a statute to get something done, for a whole lot of reasons, I need to get as broad a support, or we need to get as broad a support as we can, and you got to adapt to where you are.
Well, that's a great note to wrap up on. Please, everyone, join me in thanking our panel.